And just to follow up on some of the things that Chris was saying, I think he made there were two critical points about witness statements, which I completely agree with, and that is the importance of narrating the story in the witness's own words. As Chris says, that really will make the witness feel more comfortable about their own witness statement, and it also makes the judge more comfortable with that witness. So the narration of the story in the witness's own words, and at times as colloquial as you like, because if that's the way the witness speaks, that's the way it ought to appear in the statement. And the other thing Chris said, which I think is terribly important, is avoiding the use of conclusionary words. I think if I were asked to nominate the one mistake which finds its way into most witness statements is the sentence, "It was agreed that," in a contract case. It was agreed that. And that's a conclusion. As Chris said, what the judge wants to see in a case where the issue is what was agreed and whether there was an agreement in fact is the building blocks. And so that's why it's important in the witness statement to set out not the conclusion, but the particular facts, conduct, conversations, documents, which lead to the judge being able to draw the inference or the conclusion. We haven't had time really this morning to talk about the different judicial cultures between Sydney and Victoria and New South Wales. But those of you who might have practiced in Sydney will see that it's, I think from a Victorian perspective, quite extraordinary, the requirement for the use of direct speech. And so in Sydney, you will be required to frame a witness statement, even where a witness is recounting a conversation that might have occurred 7 or 8 years ago, such as, I saw Bill in his office, we met to discuss this. I said, open inverted commas, da-dun, 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 close inverted commas. He said, open inverted commas. I mean, I find it such an artificial exercise, but that's the way it's done. And in Sydney, it's sort of a trap for young players, they have a veritable tea ceremony at the beginning of a case where there's the ruling on objections to contents of witness statements. And it's extraordinary. You've got to be careful what you say, but it's almost clinical, like a microsurgeon of words being challenged and ruled out. So that if I were doing a case in Sydney, I would certainly require a Sydney junior to do the witness statements. I did them once in Melbourne for a case in Sydney. It was a case called, I won't forget it very easily, LMI and Balderson. It was a fight about the construction of what's now known as Etihad Stadium. And this was where the Melbourne approach and the Sydney approach were debated before a tremendous judge called Reg Barrett. And it's a decision of only 5 or 6 pages, and I regret I don't have the citation of it. But in the end, the judge, in his wisdom, allowed objections to the indirect speech of the Melbourne style as against the direct speech of Sydney, but then gave leave for the witness to give the evidence viva voce. So we spent a day more or less arguing this point, another day waiting for the judge to write the reasons, and then the witness was called to give the evidence viva voce. So, but that's the way they like it up there, and that's the way it has to be done. But it is a extraordinary, a different legal tradition. Anyway, enough from me. Would you welcome Toby to the lectern?
Thank you, Paul. having straddled both Victoria and New South Wales in my practice, I can certainly concur with what Paul has said about the differences in practice. Some of what is stated in this is informed to some extent by that, in the sense that if things are going to be red-penned out of a witness statement, you really have to be a lot more careful about the way you express things, because as Chris has said the whole time, it is your evidence, and it's your evidence in chief, and if it's red-penned out, then you don't have that evidence and you might not have a crucial pillar of your case. My talk is going to have a bit of overlap with what Chris has said. I have to apologise to Chris for that. I was originally going to try to do a bit of an example, but I figured that in 20-25 minutes and no opportunity to go away and draft, that would probably not work. So instead, I'm going to focus on some of the same themes with a few different examples, and then really take you through some tips and traps and pitfalls, as the name of this lecture suggested. The most important thing, I think, and this really comes down to what you should be doing before you start the process of actually drafting the witness statement, is knowing your case. It sounds like a simple thing, but as a junior lawyer, I know that I've been asked before to draft witness statements as where I don't have a very good familiarity with the case, and you've got to avoid that at all costs. You must know the facts in issue, you must know the causes of action and the material facts which are relevant to that cause of action. If you're going to be doing a witness statement which will involve defences of estoppel and things like that, you're going to need to know that representations and detriment and those sort of things are fundamental elements of the cause of action, and you're going to need the evidence. You also want to identify the facts in issue, and that's done in most commercial cases by looking at the pleadings. Again, this is a different situation to if you're being asked to do a proof of evidence at the start. There you'll really get the information, then you'll decide your case theory and you'll work forward. But when you're putting a witness statement together to go into evidence, you really should be able to sit down with properly articulated pleadings and determine what the real facts and issue are. You don't need to spend pages and pages going over something if the facts are admitted. I mean, you might need to include them as part of the narrative just to simply make sure the witness statement makes sense, but really focus on the contested facts that if you establish, you are going to prove and win your case. Preparation. Get to know the documents. We're talking mainly here about commercial cases, and most commercial cases these days revolve around the documents. They'll help you understand the case, and the better you know them, the more pointed questions you'll be able to ask in any interview. Because often it's the understanding of why things were done a certain way and how the documents came about that is crucial to that narrative. Then you need to start thinking about how you would arrange those documents in a logical order. The most common way to do this is obviously chronological. That usually works, but there are cases where arranging things according to issues, damages, or a certain agreement or another agreement are going to be more logical. But really, that's all about preparing for the next step, which is taking the actual witness statement. Now, in taking the witness statement, you're going to be interviewing the witness and you want to be doing that in some sort of logical sequence, and that's where the documents can come in handy. If you've arranged them in a chronological order, if you have thought about how these issues work together, then you can ask those questions. And not many people enjoy spending 2 or 3 days out of their working life sitting down with a lawyer, talking about something that happened 3 years ago that they might get in trouble about. So whilst it's a necessary experience, there's no need for them to fumble through with you while you try to understand how you're basically going to do things. So prepare before the interview, be as ready as you can, have the documents ready, have the tabs ready to go to ask them about certain parts of the documents and things like that. After all, they're generally the client, and they're the ones that are paying you, and they're the ones you have to keep happy. Another point to make in interviewing the witness is to ask open questions. The point has been made time and time again that witness statements are evidence. And if the witness was giving viva voce evidence, you wouldn't be leading them through. You wouldn't be saying, and you did this on this day, didn't you? And you did that on that day. That's not going to get the witness's own voice. What you're going to have to do is take them to the time and place, just as if those of you who are barristers in the room or those of you who are solicitors who have acted as an advocate before would say, now I want to take you to this time and place. Can you please tell me about this? Can you explain this? How did that work? And those sort of things. And that way you will get the witness's own voice and the witness's own story. Find out everything during those interviews. Don't not ask the question in the hope that, or thinking that you don't want to put it into the witness statement. Find it out there. You can always choose what to put in your witness statement later, but you don't want to find out something for the first time during cross-examination and then not know whether you should re-examine about that. You need to know the facts, then you make the judgment call as to what is relevant and what goes in. And a simple point, remind the witness not to discuss their evidence with anybody else and what they've told you, or other potential witnesses at least. We get to the key point that Chris has made time and time again, and I'm not going to labour this, but it is very important. A witness statement is evidence, and as long as you remember that, if that's the one thing you take away from today, then we may have done part of what we came here to do. You need to remember that that will probably be the entire evidence in chief of your client, or of the witness, sorry. Sometimes you can get leave to adduce further evidence. Sometimes judges will order certain parts of evidence to be given viva voce. But effectively, most of the time, a witness statement is going to be your evidence in chief. And it's got to be admissible. It's got to be subject to the rules of evidence. And Chris has taken you through a couple of examples there. What I really want to do now is, rather than giving a treatise on evidence law, I want to give a couple of examples of how you can draft to promote admissibility. Because there is a role you can play in this. Evidence is not clearly admissible or clearly inadmissible. Some things which are inadmissible can be tweaked, or you can tick some boxes so that they fall into an admissible category, or an exception to inadmissibility, to use the double negative, which is actually the structure of the Act. So first example, expert evidence. I call it expert evidence, but you don't actually need to be an expert as such to fall within the exception to that kind of evidence. What the Act really says is that the opinion which is given, which is the conclusion, needs to be based on the study, training or experience. And the point there is that we're not talking necessarily about a professor who's got 30 years and written numerous papers on a topic that has no understanding of the facts. If a witness has 20 or 30 years experience in a certain area and they can give evidence of certain opinions about what happens in that area or that particular industry and things like that, which are based on that training, study or experience, then they can give that evidence. It's a matter of setting out what the relevant study and experience is, and then saying how the opinion is based on that. And so I'm not trying to suggest that you use your lay witness to give your expert evidence. What I'm trying to suggest is that certain observations can be made during the course of a witness statement. I'm thinking of a case which I've been involved in with gas pipelines, and the same people constructed a gas pipeline, and there's a fight about that now, and the same person has been involved in the operations and maintenance of it for the last 10 years since. Now, they will give evidence of the facts as to the construction and what happened there, but they can also give evidence as to the damage based on their experience of working in operations and maintenance on that pipeline for the last 10 years. They can say where things have gone wrong, and what you need to do is you draft it so that that opinion is clearly based on that experience. So I have worked in this position doing this for the last 10 years. In that time, I have observed this. I have seen this. It leads me to think X, Y, Z. Second example, and this isn't really a rule of evidence, but it's just something that comes up quite regularly in commercial cases, and I think it's important to think about, and that's construing contracts. And as a general rule, evidence of subjective intention is not relevant when construing a contract, but evidence of surrounding circumstances and factual matrix is. Now, as a result, you want to get in evidence of surrounding circumstances and factual matrix, which is relevant, that might assist in the construction of your case, but you don't want to be putting that in a form of, we thought this had happened, or we did this because of this. You want to be putting in evidence, this event happened, prices changed because of this, we restructured the business because of this, those sort of things. Let the judge then construe that based on those surrounding circumstances. But if you can frame the evidence in such a way, and when I say frame, I don't mean put words in the witness's mouth, but make it quite clear. Ask the questions about the surrounding circumstances. Don't ask the questions about what they thought the contract meant. A third example, and this comes from my my non-commercial practice, and I apologise if this is a bit small, the writing, but this is to do with hearsay. And Chris has explained, or at least put up, what an example of hearsay evidence is. And there's an exception to the hearsay rule, which is in Section 60 of the Evidence Act. And it says, the hearsay rule does not apply to evidence of a previous representation that is admitted because it is relevant for a purpose other than proof of an asserted fact. So evidence can sometimes have more than one purpose, and this is really coming back to understanding your case. And the example I'm thinking of is, I recently drafted a number of affidavits in a default judgment and defamation proceeding. The evidence, the publication was not, it was not denied in the end because we had a default judgment, but the extent of publication was certainly an issue. We pleaded that it had been published to at least 5 people, but we suspected and thought that it had been published to basically an entire town of 20 or 30,000 people. This was the distribution of some defamatory flyers around a small Victorian town. So the issues the facts in issue were the extent of the publication, the damage to reputation, and the hurt, distress and embarrassment which the plaintiffs had suffered. Now, I had about 6 or 7 pages in 2 different affidavits on the plaintiffs, which could all effectively be boiled down into simple examples like this, which is, somebody told me that somebody knows about something, that this was said. So I'll ring the second one. My wife rang me. During the course of our telephone conversation, it became clear to me that her son, my new stepson, had been teased at school over the flyer. I was absolutely devastated to learn that my new stepson, who I had then been trying to form a relationship with and who I wanted to care for and protect, had been teased because of the flyer. Now, that's paraphrased. I didn't want to put up pages about the actual conversation. But that's clearly hearsay if I'm using that to prove that her son had seen the publication, or that somebody had seen the publication. So if I was using that to prove the extent of the publication, it's a hearsay purpose. But what I'm using it to prove, and what I'm trying to make clear that I'm using it to prove here, is not the truth of the fact that somebody saw that publication, but the fact that my client thought they did, and that made him hurt and upset, devastated, distressed. So the point is, the fact in issue is the key thing. You need to point out and signpost effectively to the judge there what happened. And this assessment of damages, the first half hour of it was spent with objections to my evidence, and all of them were, whilst the judge initially looked at it and thought that's quite strange, he wasn't a judge that had dealt with defamation proceedings regularly. After a while, he realised that the purpose of that evidence was to prove the hurt, distress and embarrassment, or the primary purpose, and all of that evidence went in. Now, the great benefit under the new Evidence Act is if you can get it in for a non-hearsay purpose, it can go in for all purposes. That's subject to a discretion, but what I'm effectively trying to say is, if I had have drafted that as, we know that everybody's, to paraphrase, we know that everybody saw the publication because I was told this. That would be inadmissible. But because it's drafted as, I know that I got told that everybody saw this and it really upset me, it's prima facie admissible. I know that hearsay evidence is, is a difficult thing sometimes to think about, particularly at 8 in the morning, but I hope that was an example which shows you the different purpose and the way you can actually draft something. What to include? Chris covered this, so I'll skip over this quite quickly, but the key here is don't just blindly include everything that the witness tells you. You need to add some value. You need to know what is relevant, what is legally relevant. The witness knows their version of the facts, they know their story, but you need to have the courage to limit that evidence where you can. And the benefits of a tight and concise witness statement are effectively that the court focuses on what's important, and you keep the judge's attention and you keep them on side. And there's nothing a judge likes more than knowing exactly what they have to decide, being told this is the key issue in dispute, and then letting them decide it. The question of whether to anticipate the other side's evidence comes down a little bit to what Chris said and how witness statements are going to be structured, whether there will be a statement, then a statement in reply, then an opportunity to reply to that. What I would say is don't just blindly include everything that you think might need to be said to respond to cross-examination, but also don't do that. Think about it, make a judgment call, but often you will have an opportunity to respond, whether it be via way of re-examination after cross-examination, or whether it be by a reply statement. The point is to think about it. Formatting, simple things, just comply with the orders. You can put some judges offside with very minor things. You can fall afoul of, particularly when it comes to affidavits, admissibility by not complying with the rules, not hitting the deadlines. And you'll find that some judges really do focus on that. Some magistrates really focus on that, and those that appear regularly in some of the Melbourne civil lists in the Magistrates Court might understand what I mean when I say that, but there's no need to distract. It's simple stuff to do. Protect privilege. There's, in the case of the ACCC versus Cadbury-Schweppes 2009 decision of the full court, the court distinguished between draft and final witness statements and when it talked about whether privilege subsisted in them. And it found that privilege didn't subsist in the final witness statements, as the dominant purpose of the final form witness statement was to file and serve at trial, not to prepare it for the legal proceedings. So just as a simple note, keep a draft note on it the entire time until you get to the point where you exchange or file in court. It will enhance your arguments for privilege. I might hurry up a little bit here. Being persuasive, enough has been said about that already. Tell a story, tell a narrative, let the witness's personality come out and their version of events come through. The key point here, which has been reiterated as well, is do not put witnesses' words in the witness's mouth. Use the witness's own word. We have the Associate to Justice Judd, who I think Luke was sitting at this time. A very useful quote from that judgment, and really one of the key reasons why that claim failed was because the judge was not willing to accept any of the what he called formulaic evidence on reliance. So overworked witness statements discredit the witness, embarrass the legal practitioners involved in their preparation, and undermine the trial process. I place little reliance on these formulaic passages. And the point has again been made about the use of the witness's own words. The truckie says got fired or went bust. Use those terms. There are certain terms when you're in an interview with a client that jump out at you, turns of phrase, those sort of things. If they jump out at you, chances are that's that's the way to really convey the witness's voice. So ask them to repeat that. So can you just tell me what you said again? And if the actual meaning of the phrase "went bust" is important in this, if the question is somehow to do with insolvency and whether they could pay their debts and as when they were due and payable, then you ask them to explain it, but you don't change the term to insolvent. You say, "What did you mean by went bust?" And you say, "Went bust, by that I mean X, Y, Z." Again, use direct speech where possible. I found the one point where Chris and I have gone afoul of each other, and after discussing it with him, I think I probably agree. Words to the effect, I think the point is that you're trying to distinguish between where something is being said in direct speech, which is always preferable, and where you're effectively giving the substance of a conversation. And the example, I use words to the effect sometimes because I can't think of anything better to say. But the example is really something like or along those lines, just what a witness would actually say in their own words. And I think that is a smart point, but it's really introduced the fact that the witness can't recall the exact words used in the conversation, then say in substance what they recall of the conversation. I think Paul and I didn't collude on this, but the avoiding of legal conclusions and vague terms. In an oral contract case example, Joe Blow agreed to sell me his car. Now that's a legal conclusion. That's inevitably what the case is going to be about. Use the words which were used in the conversation and let the judge draw the conclusion that an agreement was made. Structure, make it easy to follow, logical, appropriate headings, consider an index for a long witness statement. Writing style, again, all of these drafting tips are based on the idea that you're still using the witness's own words, you're just trying to make it as easy to follow as you possibly can. So don't put words in the witness's mouth, but try to break up sentences, try to break up ideas, break up paragraphs. Something which I learnt from practicing in Sydney is if you only have one idea in a sentence and you only have one idea in a paragraph and somebody has an objection to part of that, then they can only put the red line through that sentence or only the red line through that paragraph, and you don't necessarily lose all of your evidence. As soon as you start conflating things and stringing things together, you risk everything being tainted. So not only is it clearer to read, it's easier from an admissibility perspective. Another thing, smart positioning. I think this is something which is underutilised in the legal profession sometimes. It's particularly useful in submissions, but in witness statements where you need to give evidence, something needs to be said. You have some very strong points and you have some weak points. You want to give a fulsome account, but you can always put the important point under the subheading at the front of a paragraph, and you can put the other more damaging point in the middle of a paragraph. It doesn't mean that it's not there, it doesn't mean that it doesn't get noticed, but it softens the effect of those kind of things, or it can. Drafting, again, subject to the rules of using the witness's own words, always draft in the first person. It's the witness's evidence, it's not you telling the court what the witness's evidence is. If possible, use the active voice. For those of you of my generation that weren't taught grammar at school, effectively, if you try to put the person or the subject doing things rather than having things done to them, then that will assist with that. You'll generally find that shortened sentences, it makes them clearer to read. And finally, as I said, junior lawyers, a number of who will draft witness statements, to the extent you can without losing the witness's own story, try to use proper punctuation and the like. Judges and magistrates and arbitrators and tribunal members have generally been taught those sort of things, and they care about them even if some of us don't. That's really it for the day. I have, to assist, I've always enjoyed or found useful single-page desktop hints, and I produced one of those for drafting a witness statement. So it contains effectively what was in that statement there, but just a useful checklist, and Luke will be able to give you that on your way out. Thank you.
Toby and Chris, thank you very much for the time you spent in the preparation of those papers, which I think were really valuable. Just listening to Toby, he made one comment which I attracted my interest, and that was addressing the way in which one should prepare witnesses in the preparation of their witness statement, and that was his comment to remind witnesses not to discuss their evidence. And it's one of those things which is important to say, but of course every witness, when they go back to their office, is, if they haven't already, naturally going to discuss the discussion they had in the solicitor's office or in the barrister's office about their witness statements. And they'll talk about what questions they were asked and the answers they give. It won't matter how often we say to them, look, it's really important not to discuss your evidence with Joe Blow. What you're really doing in saying that is to protect the witness. And it reminded me of one trap, if I can use as a footnote to both Chris and Toby's papers. One trap is the common mistake of seeing two witnesses who you'll be calling to give evidence about the one subject matter or a conversation, that you'll see the two witnesses together at the same time. Those witnesses will expect that you'll want to see them together. They won't understand why you say, I'm awfully sorry, could you come back tomorrow, to one of them? And some might be a little bit offended by it. But what you're doing is protecting those witnesses from cross-examination along the line that they have colluded. And it's a very important point, I think, to maintain so as to protect the witness. The unfortunate outcome is that you will find that two witnesses sometimes have very different recollections of the same conversation. That's okay, provided that the nub of the conversation is essentially agreed. It doesn't matter that their recollections are different around the periphery of things. What happens when you've seen both of them and they give different accounts, you can't go to each witness and say, hang on a minute, that's not what Bill recalls. Bill says that this happened. The vice in doing that is the same vice as seeing the two witnesses together. You can't coach the witness. All you can do in that situation is question the witness in such a way that their recollection will be provoked and tested, and one hopes come to the same conclusion as the other witness about the essence. But the quotation from Justice Judd about embarrassing the legal practitioners, and I've forgotten what was said about the witnesses, is very apposite. There's a very high degree of responsibility on the legal practitioners to prepare the witness in the giving of their evidence, but at the same time to protect the witness from himself or herself when they go into the box. This little footnote has occupied, unfortunately, time for questions, so I'm sorry about that. All right, well then may I thank Chris and Toby on your behalf again.